First of all, turning to the policy, what we say is we don't need to show that there's the policy shows in principle or any of the other tests which I've already addressed, Your Lordship, are advanced by my learned friend, in order to show that the plan identifies for potential development. But we do also say, as it happens, in this case, the plan and the common position before the High Court was that it did. And
did what?
The plan did identify the land in principle as suitable for development. And we go to that was a common position before the High Court, and that's recorded in the judgment of Mr. Elvin. It may be just useful just to go to it. I'm not paragraph 65, page 76. I think my learned friend went to this paragraph, but rather to the top point about the meaning of the word potential. And I just for the position that was before the High Court, and there may be, reading from 6 lines up, there may be specific cases where the plan constraints do bear directly on the land and might, on the facts, preclude potential development, but this is not a case. So he's talking about how it ought. Mr. Morgan accepted there were no constraints that applied to the land. Indeed, it's clear from Section 78 appeal decision, he gives the reference, and that's an appeal by the claimant, we have that decision, that the council had not disputed that the land was suitable in principle for development. And if one goes to my opinion, which my learned friend Mr. Brown referred to,
just before we do, you say we've got this appeal decision?
We have the appeal decision, yes. Your lordships don't have it because it's not in. We've got it. If you lordships have any doubt that the judge below misinterpreted it, but that was the position. It is important to understand the position between accepted between the parties in the court below, because the way in which I know Mr. Brown wasn't involved in the hearing below, but the way he now puts it before your lordships. And
when the judge says Mr. Morgan accepted there were no constraints that applied to the land, does that tie in with what you were saying just before lunch about the possibility of countervailing policies such as open space policies or something like that?
My lord, yes, that's my understanding. With this case, in this case, Mr. Brown now seeks to pray it in aid as a point of principle. The only policies engaged were the ones we were looking at in respect of obviously this land, and whether those policies identified this land for potential development.
I follow that there is on the facts of this case there is no countervailing policy relied on.
Yes.
But if there were to be,
it's a different case. It's a different case because it's common trite planning law that a development plan, and we look as a whole, and does this plan policy document identify the land for potential development? In this case, we have the 2 applicable policies, the only effective ones that were in terms of the principle of development or potential. We say potential, but even if the bar is moved to principle, in the court below, that was accepted. And if one goes to my opinion also at 351, and again we have 354, to which Mr. Brown referred to, but didn't take your lordships, but did refer to. So 354, paragraph 11. I think this is main opinion. I referred to an example. There have been a number of planning applications on this site, but the position of the Wiltshire planning officers. And the current, paragraph 11, the current site is within the limits for development of Royston, Wootton Bassett. Wiltshire Council, having considered these policies as previously accepted, we quoted, the location of the site is therefore considered appropriate for development in principle. So I'll give the reference. Again, we haven't put it in because it hadn't been an issue. We don't say we have to go as far. Potential doesn't require as far as our site is concerned. But our site has been refused planning permissions on its impact on neighbouring properties and the scale and all of those things that Mr. Brown says are okay. Ironically, to properties, I think some of which have been built outside the development limits, but there we are. And now it's been refused again, obviously because for the same sorts of reasons, but also because it's a village green. But that's because of the statutory issue. So, my Lord, it's important to see, if we are appealing against the judgment of Mr. Elvin, what the position was of the planning authority in the court below. And that is one of accepting that it's appropriate and in principle. I make it very clear, as we've made throughout, that threshold is beyond what we say is necessary for potential development. And there is no ground of appeal, as far as I'm aware, that the learned judge below was wrong in that part of his judgment in recording the position of the council in respect of their understanding of those policies and acceptance of in principle and or appropriate. But, my Lord, it is right, if we go to then turn to the policy, it's absolutely right that they do, because if one goes to the policy, one has to understand the function of a core policy. The core policy in Bundle 1, my Lords, of the supplementary bundle, it sets the overarching core strategy for where, in this case, the county, development is to be directed. Common ground between myself.
What are you looking at now? The policy
Sorry,
itself?
tab 1.
Page 10, the policy itself.
Policy itself, tab 1, page 10, my Lord, yes. And could I just take you to a couple of passages that my learned friend didn't take you to in support of CP1, and the first one is on page 10, 416. And it says, any existing settlement boundaries for small village, other settlements not identified, there is a general presumption against development outside the defined limits of the development of the principal settlements, market towns, local service centres and large centres. And then it says there may be modest in some of the smaller villages. One has to read the policy as a whole, which, and again, if I take your lordships to the supporting text at 415, again, talking about control outside of those areas, paragraph, second part of the paragraph, development outside the settlement boundary will be strictly controlled. Now, one has to read it as a whole. This is in contrast to the approach towards development which is regarded, and I'll come on to the presumption of sustainable development, which is presumed in principle to be acceptable. So again, I think it's beyond in this policy potential development. Development outside the settlement will be strictly controlled. Relaxation of the boundaries will only be supported if it's being formally reviewed through subsequent DPD, community-led neighbourhood plans, which includes a review of the settlement boundary to identify new development land to help meet the housing employment needs. Now, pausing there, you're reviewing it to extend it to include new developable land to help meet the housing employment needs of the community. It is, frankly, obtuse to suggest that if you're extending the boundary to include new developable land, that the land within the boundary isn't developable, in principle. And that's to help meet the housing and employment needs in the community. I mean, one of the great crises, both in rural and urban areas, as your lordship will be aware, is the ability sustainably to meet those needs. And it means not just having shops nearby, but having houses close to the shops. And that's why these centres are identified, because they have the existing infrastructure that can support additional residential development in a sustainable way. And so, and they also point out that they bring forward community benefits. But 4.15, we say supports, and this is why the council, until this appeal, have always accepted in principle this land is suitable for development, because that is how their strategy works. And 4.15 makes it very clear that if that strategy isn't working, i.e. it's not delivering, you can review to extend the area of developable land. Now, you can't extend developable land by moving a boundary if the land within it isn't, in principle, developable. Developable doesn't mean it will be developed, or it's certain to be developed, but it's identified in principle as suitable for development. Why in principle? Because it's in a location that is sustainable. That's the presumption of sustainability. Development within these settlement boundaries are presumed to be sustainable because they are in locations which are sustainable. That presumption can be displaced. You may have a development that is not sustainable. Maybe unusual in terms of, I don't know, I could think of an example, but it's a bit ridiculous immediately, but you can think of something that environmentally has other consequences. Desalination plant, which has energy things that, although physically all the workers could walk from the village to it, prima facie sustainable, the nature of the activity may be regarded as unsustainable. So the presumption can be changed, but this is being identified for development. And of course, development, although lots of the focus is on housing, isn't just housing. Could be other forms of development, which could include change of use. All of that, the detail, may be worked out later in allocations, may be worked out in specific planning applications, but identifying these areas of settlement as the areas for potential development and the land within it is clear from the development plan. And one will see, my lords, if we're still at page 9, in the supporting text, 412 makes clear that the result of the assessment of the strategic roles have been carried out. The results of the classification are set out in the settlement strategy, which is core 1, and then CP2 presents the way these settlements will develop in the future. So there is a presumption for development. These presents the ways these settlements will develop in the future. So they will be carried forward, the boundaries, but they will be subject to review to ensure they're up to date and can adequately reflect the changes which have happened since they were first established. So, for example, that would include need for further housing. You've built out, your lordships remember drawing my attention to a housing allocation in the old plan. Was it built out? We thought it had been built out. That having been built out can't serve the future needs that are identified as indicative housing for Wootton Bassett, when one turns to page 17, my lords, Royal Wootton Bassett Town. It cannot be served by houses that have already been built out. It's looking forward, so you need to update your need as the plan says, to see whether they're going to be update the boundaries by pushing them out. But that is to include, in the words of the supporting text, new developable land. And all of this is part of what is presumed to be sustainable development, because the location is presumed to be sustainable. By contrast, 416, there is a general presumption against development outside. So in answer to my Lord's question, all land has potential for development, My Lord, I would have difficulty advancing to your Lordship that a site out with CP1 and CP2, a greenfield site, where there is a general planning presumption identified in the plan that this land is not to be developed, is one that's been identified as having potential for development. So that's a very clear answer, that if you have land...
Yes. Although it may have it, it hasn't been identified for having it.
With,
Although it may have it, any piece of land has development potential.
Hasn't been identified.
It hasn't been identified for
Well, it goes further than that, my Lord. The plan has identified a presumption that it won't have.
Yes, the presumptions are just that. They're not irrebuttable.
My Lord, that's right.
So
Hence,
looking at potentiality, the potentiality is there. It's just at a very much lower level of probability.
my Lord, then presumption, I agree. So, I mean, on the facts of this case, we go beyond potentiality and principle of development. Our site is a very good example of a site that the council accepted in principle was suitable for development, but refused on a number of occasions specific proposals because of their details. Doesn't mean the site doesn't have the potential or in principle acceptable for development. But the reason we say on this case the judge was right in any event should not undermine the bigger picture, which is obviously important, that one doesn't have to be in the position that my clients are in their site and their policy in order to satisfy the test of potential. Development plans take quite a long time to work their way through. There have been various reforms. This was a core strategy that then had other DPDs coming through, and there is change again to another development plan system. But there's still those where you have your core strategy, and then you would have other DPDs come forward with specific development control policies and site allocations. Now, site allocation is really, my learned friend at the end fairly put his case. He says it's got to be a site allocation or something akin to in terms of certainty with a site allocation. I've addressed your lordships as to why that doesn't meet the literal meaning or the ordinary meaning of potential. But what I want to do is take your lordship on to whether or not that would frustrate the purpose of the legislation. The answer is yes. Because it would stop local authorities, if they identify, as this authority has, areas for where development has been identified as the areas where potential development would come forward. If that isn't good enough, if what this authority's planning officers, who we don't hear from today, other than in the documentation, CP1 and CP2, if that's not good enough, as soon as you do that, you risk the very mischief that Mr. Brown accepted. That is, applications going in for village greens in areas which have been identified for potential development. So if potential development doesn't mean what it says on the tin, but your lordships are persuaded by my learned friend that identification of potential land means it has to have a degree of certainty that it is likely to come forward or in principle acceptable, none of these words chosen by the parliamentary draftsman, then the mischief will remain. Because the plan process will not be able, or there's a real risk, the plan process won't be able to move straight to specific allocations. But let's take a specific allocation. My learned friend appears to accept that a specific allocation would be acceptable to him as identifying the land for potential development. Now, some authorities take a different approach to Wiltshire, and they decide, we've been giving evidence, Chichester, I promoted their local plan last year, Cotswold District Council, and the whole focus of development was on an extension to the principal town of Cirencester. We weren't focusing on hierarchy of settlements. going for that. And that, I suppose, would be seen, an allocation of that nature of satisfying Mr. Brown. But within that, there are areas of triple SI, substantial areas. Now, does Mr. Brown say that that has been identified, that land, triple SI, as potential development or not? Can't have it both ways. It's in the allocation. And of course, as the learned judge below rightly pointed out when he analysed some of the allocation, he analysed one of the allocations and the constraints. He identified, if one looks at, bear with me one moment.
Bubble fill, whatever it's
Yes, if one looks at page 31.
Yeah.
Yeah. So if one looks there, there is land that will not be developed upon, that will be a strategic gap or have a strategic function. How does that land sit with the village green interpretation that my learned friend would give? Would that be land that, because it's not actually developed on, it's used for landscaping or other such uses? Is that identified for the potential for development or not? Because once planning permission is granted, then it's out for village green. So the fact that even within an allocation you have land that when actually you look at the actual other policies or legislation, or even applying planning policies, will not be suitable for development. It may also be there be flood areas.
Well, we know from page 33 it's got to include public open space.
Yes, my lord, precisely. So we know, we say, well, we know that there's going to be public open space that's not going to be developed on. How is that identified as potential development, likely to be developed? But all of it is within the allocation. All of it's identified as land for potential development. And even within the urban, the village environment, listed buildings and such like, there's potential development there. It will be a matter of planning judgment or what have you, but it will be treated differently to a listed building or an area outside of the development limits where there is a presumption in favour of sustainable development. The reason this policy is structured in the way that it is, after examination, this is the strategy. The hierarchy of settlement is to say development is presumed to be better within these constraints. That's your starting point. And this is the area for potential development. It doesn't mean that all of that will be developed in built development. Some of it may be open space, some of it may not get developed for all sorts of reasons. But the area for potential development is the areas identified by CP1 and CP2. If you were coming as a developer or to look at land to invest in, and you were asked, where is this council indicating where the potential development is going to be? Which land? You would point to the land within those settlement limits. That's where the potential development, and that's where the council want the potential development to be. They don't want it to be in open countryside, this council. So, my lord, just quickly then looking at CP1 itself at 10, we emphasise, and I know your lordships have it, but we the settlement strategy identifies the settlements where sustainable development will take place to improve the lives of all those who live and work in Wiltshire. So that's the starting principle. The principal settlements, and then we move to market towns, and it said outside the principal market town as defined, and again I emphasise the word as defined, as settlements that have the ability to support sustainable patterns of living through Wiltshire. Market towns have the potential for significant development that will increase the jobs and homes in each town in order to sustain and, where necessary, enhance the services, better promote levels of self-containable and viable sustainable communities. And then it lists them. And then the delivery strategy, CP2, if we turn to 12, seeks to execute that. And remember, in terms of development, it's not just houses, it's also jobs, 4.18. The delivery strategy recognises that in some settlements, new jobs have not necessarily been delivered alongside new homes. It will strengthen communities, allowing appropriate growth to provide for the most sustainable pattern of development within Wiltshire, etc. So then the underlying principles, 419, are to ensure that communities better balance. This underlines the focus of the settlement strategy to support growth in the principal settlements, which provides the greatest opportunities, and within Wiltshire to improve self-containment and potential to generate job growth. And then 420, my lord, it's set out, the proposed strategic housing requirement is set out against defined sub-county areas that's identified in what's called the SHMAR. However, in order to support the most sustainable pattern of growth in line with the principles and see, indicative requirements are provided for each principal settlement, paragraph 4.26, market town and community areas, and that's what we have at 4.26. So in order for this strategy to be achieved, which is to identify these areas as the areas for potential development, even at this level, a view is taken that they will be delivering. And that includes, as we can see on Royal Wootton Bassett Town, just over 1,000, and then there's the remainder of 3,885. And that's because there is a view taken that areas within that area are suitable for potential development. Now, one doesn't have to look very hard. Can we just, I mean, this is to have, at the insert plan, if one could look at the insert plan, which shows the current settlement boundaries. So this policy applies to those current settlement boundaries. And my learned friend rightly drew attention to, he said, school playing fields and others, to look at this settlement boundary, and this is the approach of the council, and reading the plan as a whole, that just over 1,000 dwellings may indicatively may be being delivered. So when one sees how the council itself views the operation of the policy, it is plainly identifying areas within the settlement boundary as areas of potential development.
I think we've been over this point.
Yeah. Well, I'm just making the actual fact is, if not on these, where is the development, potential development otherwise? This is just a matter of the risk of saying common sense. But the interpretation that my learned friend gives is, no, this plan's not identifying any potential area. According to my learned friend, apart from any allocations, plan doesn't identify any area for potential development.
No, not quite what he says. He says it doesn't identify every postage stamp within it as
What it,
potential development, and in a sense you accept that because you accept that there can be a countervailing policy which can take a postage stamp or a larger area out of suitable for potential development.
my lord, that's right. I mean, it identifies the area. I think the problem with my learned friend's approach is that he has to redefine potential to mean likely, and this site is likely to get developed. The reason why you have a settlement boundary for potential development is because it's identifying potential development. It's inherent in the word potential that not necessarily all of the land will come forward that's identified for potential development.
But you also have to read something in. I mean, you have to read in, as I think you now accept, a saving for any countervailing policy indications which one might find elsewhere in the plan.
My lord, no. I'm just applying normal planning policy, which is not an issue in this case because it's not. My learned friend throws out hypotheticals. What if this? What if that?
Well, one has to do that to test the boundary, given it is a pure point of law.
Well, it's a pure point of law, but all points of law apply to the actual facts and policy of the case. My learned friend wants to have it both ways. He wants to say this case is all about CP1 and CP2. The judge hung it all on CP1 and CP2. Well, not surprisingly, because the council didn't advance any other policies against it. You could have a situation where you have a piece of land, CP1 and CP2, that identify it as the land as potential development. It is conceivable that in another scenario you could have a policy, someone amends a policy in clumsy form, so you've got policies pulling in different directions. Let's say someone amends the policy, Wiltshire amend the policy for Royal Bassett, and they do it in a clumsy way. So you've got for one piece, a policy for another piece of land that has, this is on this piece of land.
Well, take the cemetery, which
Let's-
Mr. Brown
Yes, the
said was
cemetery.
within the settlement boundary.
Yes, take the
I imagine there must be either, if not planning policies, then ecclesiastical law constraints on development.
well,
of the
actually, you
cemetery.
would have to come to either Mr. Petchy or myself as deputy chancellors and apply for chancellors for a faculty. It's not my area, so I haven't got a conflict. But you would be out where if you for development, and there's all grey cemeteries have statutory provisions as well.
Right. Well, okay. So they're in the they're in the settlement boundary.
Yeah.
So what do we do when somebody applies to register part of the cemetery as a TV?
Well, as matters stand, the question is focused on not whether there's ecclesiastical legislation, not whether there is an Act of Parliament requirement. It's whether the development plan identifies that land for potential development based on CP1 and CP2. It does. And that's the focus. So that cuts out the village green. The fact that you might need an Act of Parliament or whatever is another matter. That's not a trigger event, or that's not a. So we need to focus on what the legislation was about. So far as planning policies are concerned, I mean, Wiltshire may or may not be, their village green officers may be upset, but they haven't actually been able to persuade, I don't know what goes on within the authority, the planners to have reviewed their plan if they had any concerns.
But what about school playing fields? That's another example Mr. Brown gave us, I think.
Yes, and they may have the potential for development, yes, on CP1, and many school playing fields have been developed. I'm not saying it's a good thing, it's a matter of planning policy judgment. If this authority wants to make planning things protecting and taking out cemeteries, village greens, what have you, it is its planning job to do it, not to use the village green mechanism. I don't know why this authority, as a registration authority, has any particular. It's not coming here in its planning capacity. It doesn't have any village green policy to pursue. But anyway, that's another matter. But it isn't the right forum to interpret the legislation because you're worried about what's going to happen in the planning system. And that's at the heart of this authority's case. Ironically, because they could be in a situation as a registration authority that in a two-tier system that the local planning authority who makes the plan is not them. Ironically, in this case, there's the interchange with this authority is unitary and it makes its own plan. So arguments about the arguments about development on school playing fields and such like, what would happen to them, is irrelevant to the question before your lordships with respect. Is land identified the potential for development? And if you've got CP1 and CP2, yes it is. That development may take all shapes and forms. And my learned friend seems to posit it's always built development of a certain type. But as he readily conceded, even a village green would be development if you were changing from arable or nil use to recreation. You'd need planning permission. That would be development. Now, just because there is a presumption in favour of development or land is identified for the potential for development, school fields, take for example planning, they would require planning permission if you wanted to create a new playing field, new sports pavilion, etc., etc. That's quite so. I'm a school. I want to develop my school playing fields. I don't have the problem that I would have if I was outside the settlement limits, where I wouldn't be allowed to put up the posts, and or in the green belt. There's exceptions for recreation, but limited.
In essence, really, I think really what your argument comes to is if you're the school governors and you want to do something with your playing fields, then really that's a question that should be addressed on its planning merits through the planning system, and not stymied by registration of a TVG.
My lord, yes, and often that what happens, you've got playing fields are very vulnerable in village green cases where people walk their dogs across it. The school is generous and let them do it, and then they want to develop, extend the art facility, and you've got the locals all registering as a village green, and then you've got child protection issues as well. But anyway, that's a side issue. So the fact that what Mr. Brown is trying to get the court to do is make a planning judgment and say, because this policy can't identify for potential development because it has a school playing field in it. Well, school playing fields could be developed for housing. They may even be enhanced, which would require applications for planning permission because it's development. They may want to put up floodlights. That's development. They may want to create a stadium. You know, I've had my old boys rugby club putting up a little stand. That's built development. That would require planning permission. That's development. Now, CP1, CP2 would be in their favour because this would be, if I was the school saying I want to extend the art facility, going over green land, I'm in CP1, CP2, presumption in favour of sustainable development. This development is sustainable. This maintains a secondary school at a village that otherwise the numbers are getting too big. The children would have to go by car to the neighbouring, to Swindon or wherever. So development, as the policy makes clear, is talking about all the elements that sustain a sustainable form of development. And the presumption is, if your land within it, school playing fields, cemetery, there's a presumption, well, potential for development, I would say, but it's presumed that you will be sustainable. Your Lordship rightly said to me, well, what it put in the policy was a presumption in favour of sustainable development, and I'm saying it presumes that the development will be sustainable. Your Lordship's right about the wording, but why is it put in a policy? Generally, as your Lordship knows, the general national policy is presumption in favour of sustainable development. When you read the policy as a whole and in context, what it's doing is saying these are the sustainable locations where these are locations where we say there is a presumption that the development will be sustainable. And you put a line around it in crude terms, and it's presumed that land within there has the potential for development. In fact, even further, a presumption of sustainable development. That doesn't mean, as my Lords rightly said, presumptions can't be rebutted on individual cases. But we're looking at a very low threshold, deliberately, potential for development identified by the plan. Not, to answer my Lord's question, that every land has some potential, however removed. That wouldn't be a potential for development identified in the plan. And in terms of my learned friend Mr. Brown's argument that the case initially developed, and I know Mr. Brown is not going back to that, but we're saying, well, it's got to be the individual land, the same one as the village green application, and that argument was abandoned below, quite rightly. It doesn't have to identify specifically any land ownership, as long as you're within that policy. And once you're within the policy, and once it's potential, as we have here, then it is done.
Is it of any relevance that what we're dealing with, I mean, one can see this from the way the legislation is framed, is an exclusion of a right which one would otherwise have? I mean, Schedule 1A is headed exclusion of right under Section 15. So, I mean, Parliament starts by recognising, you may not like it, but you have to recognise the fact that there is a right to apply for registration of a village green if certain conditions are satisfied. That is then cut down in the ways which are specified. But, I mean, given the way it is structured, may there not be an argument for saying if there is any doubt about the extent of the cutting down, one should, if anything, err on the side of making the exclusion sort of narrower rather than wider?
My Lord, there's an argument, but it'd be a bad argument with respect.
Yes.
Because you're starting halfway through the process. The beginning part is the right of private ownership of land. And statute by the village green legislation intervenes, as we said in our supplementary skeleton argument, intervenes for justifiable public reasons to codify and impose what were historic conventions, and Parliament codified it into a legal regime, which interferes with what would ordinarily be an individual's constitutional right under the common law to do as they wish with their land. What this legislation does is modify an intervention. So it takes away a draconian intervention given to third parties by redressing the balance. So if there's any doubt, it should go, in my submission, one should look at holistically, not just in part, at the interference by Parliament. The interference by Parliament goes back when Parliament, by legislation, introduced legislation expecting that all village greens would actually be registered by a period of time, but that never happened, and we've seen it ongoing. And that's caused the problem that it's caused, and Parliament then intervened again, albeit over a considerable period of time. Yeah. But the starting point, however, and the way that the European Convention of Human Rights, the way in which this country's common law would look at it, is that we start with, if any doubt, it's in the right of the landowner, who's quite frankly a draconian right for people to lose the right to use their land, which they would otherwise lawfully be entitled to as they will. So that's why I would say, with greatest respect to my Lord, one can't just zoom in part of it. In a sense, Parliament is seeking to redress some of the mischief that its other intervention has caused. It may be an unintended consequence, but that is what has happened. That the village green has been, it's on the list. We all have it. If we were instructed to try and oppose her development and stop it, great crested newts, village greens, all of those things. Parliament, but this is a product of village green, town and village green. It's a product of our own legislation, and so Parliament is modifying what would otherwise be the case. My Lords, can I just also take another step back? If your lordships are to follow my learned friend's approach, which is to read into potential something more than its ordinary meaning, which is simply the potential for development, and then impose some likelihood, say more than 50%, is that perhaps? More than 50%, because it's a matter of law, more than 50%, or so that you're sure, an allocation, policy like an allocation. So an allocation where it's been pursued through a development plan with usually with an outline master plan showing the outline uses. And he says you've got to have something akin to that. If you adopt that, how do you adopt that as an interpretation of potential development? Is the court going to say that in order as a registration authority to carry out your statutory duty, you have to carry out an in-depth planning examination? And my learned friend Mr. Brown touched on this, but it's a point against him. He says, oh well, Mr. Jones says that you could have policies carving out, or my Lord Justice Lewison says, well, what about if you amend you can write your settlement boundary policies however you want. I'll come back to that in a moment. But he was saying, well, you'd have a Swiss cheese vet, all these. How are you supposed to, as a registration authority, know about all these competing policies? How are you going to make this planning judgment if they're pulling in different directions? The short answer is you don't need to do that, because Parliament has told you, you just look and see, on advice, I would say on advice from the planning authority, not direction, as to whether or not the land has been identified for potential development. That's all. That's all. Not getting into, oh, if a policy pulls in another direction, what's the likely outcome? Is this likely to ever come forward as a development? What if someone says the site's not viable? It's never going to be able to support the contributions under SIL that the local authority policy demands. So you could, it's never likely to come forward because it's got an in-principle problem that you need to have improvements to the dual carriageway, and this site will never fund it. That's scenarios that happens to sterilise sites. All those problems arise for this court if this court seeks to imbue with the word potential and identify potential development something other than its ordinary meaning. They go away if the registration authority is allowed to carry out its statutory function, which is supposed to be blind to any policy on village greens or whatever, just like a judge, and carry out its statutory function to say, is this land which has been identified in a development plan as potential for development, or in a draft? That's a should be a relatively straightforward question. If you get into where Mr. Brown wants to lead the court, not only is it contrary to the statutory wording, but it then is going to create a whole mass of litigation.
But I thought you had accepted that if there were a countervailing policy in the development plan document, that is something that could be taken into account.
You could, yeah. If you had, for example, and the statute allow, if you had, for example, an amendment to the plan, so CP1, CP2, or then you amend it and you say they don't apply to this school playing field, then you look at it and you say it's not been identified by the plan for potential development.
But suppose you hadn't amended CP1.
Yeah.
And you had CP1 saying land within the settlement boundary is identified,
and then
open spaces policy 1,
yes,
let's say,
saying
no development on school playing.
Yeah, unless exceptional circumstances or something. In those circumstances, I would be reluctant. Reluctant to say that the land is not still identified for potential development, because once you get into making planning policy judgments, it could be said, for example, oh well, this land is say school playing fields. There may be very good reason why a local planning authority will come to the view that it's nonetheless in accordance with the development plan policy. Our submission would be that you've got to be very reluctant to start getting into carrying out what's effectively a planning balancing exercise. Once you do that, you're on a slippery slope. Now, obviously, my learned friend, of course, is advocate to give an extreme example, cemetery, listed buildings. Listed buildings, for example. I've got a listed building. I want to convert it into a hotel and build on it. I can do that. It's quite conceivable that that could be done. But if I'm outside the development limits here, there's a presumption against development. If I'm inside, there's a presumption in favour of development. And of course, Mr. Brown's submissions have never grappled with the fact that the potential development includes the range of a development which requires planning permission under the Town and Country Planning Act. And that's what the statutory provision relates to. And so I do say that it is possible. It's possible by neighbourhood plan. We checked over lunch as well, that it becomes part of the development plan, and it would revoke. You could revoke take some land out by neighbourhood plan or by review of the development plan. But I do say, although policies may pull in different directions, if there is, in this case, CP1, CP2, we get into hypotheticals where there are other policies that may apply. The land, I would say, nonetheless, is identified. This is not the case before your Lordship, but let's say we were looking at another site in Wootton Bassett that had some other policy that Council were relying on. I would still submit to your Lordship it's identified for potential development. What that development would be, how much that development would be, the scale, all of that is another matter. That is not for the registration authority, and with respect is not for this court in deciding what is potential development. It's just potential development of any kind, unrestricted.
Yeah, I mean, at bottom is the submission that Parliament intended all these sorts of questions to be left to the planning system.
My Lord, that's right. And once you go down Mr. Brown's submission, you're inevitably, take any example, you're being asked to make a planning judgment. Obviously, as a good advocate, takes the most extreme example. Surely it couldn't mean that. Well, I mean, planning can do all sorts of things. I mean, the mapping and web building, I don't advocate it. Grade 1 listed building, demolished to make way. That is a planning judgment, but you can't build those plans. Mr. Brown wants to import into the exclusion of register. All it is excluding of registering a village green. It's not determining the planning application to say there's got to be this high threshold. Yeah. And again, I was on. I know your Lordship, my Lord, is very familiar with the West Kensington decision. I was on the wrong side of that. I was arguing the Paul Brown, Mr. Brown's point. I was arguing that identification, you need to really drill down. And when you looked at the London plan, it was a very general provision. So, I mean, Mr. Brown focuses just on the dictionary definition, but insofar as it's relevant, my Lord, it supports our case insofar as it's relevant because, as Mr. Justice Lindblom, as he was, found that you didn't take much to identify in that area it was an area of growth and stuff. Not all of the area in there was going to be, and of course part of the controversy was the flat development. So we say that the judge was right to rely on that, and if I could just take your Lordship to
so that's followed up. That's a nice.
Yes, just to the judgment, and I don't think, unless your Lordships wish me to, there's much more I can say on the policy. We've highlighted, in my opinion, I mean, at the end of the day, I thought, well, my opinion's disclosed, so it's there. So I would say it's a very simple thing in this case.
You won't give it any more weight than your submissions, Mr. Jones.
That's right. But all I say, as I said out there, it's actually very simple, and that once you depart from it, simplicity, then one gets into great difficulties. And one of the difficulties below, and one of the difficulties, although Mr. Brown has pitched it pretty high, is to say, if not potential, what then? And then once you're pushed, and that was one of the problems for the council below in setting forward what's acceptable. once you're pushed, and then, as Mr. Brown finally said, you're looking at allocations, or akin to allocations. And that is so far away from the statutory wording that one can see that the purpose of the legislation would be severely undermined. Turning to the, can I just go to the judgment, and if I may, and I've taken your lordships to paragraph 65. I won't go there, but criticism is made by my learned friend of inconsistency at page 66, paras 32, but paras 33. And I would say, with the greatest respect to my learned friend, this uncharacteristic, unfair criticism of Mr. Elvin for this reason. If you see what he's actually saying, my submission, in my judgment, the purpose of the requirement is to identify the land for future development, is to create a sufficient nexus between the plan and the land so that it does not fall within paragraph 4, simply because there are planned policies that generally encourage certain categories of development or in certain circumstances. To do so would unduly restrict the rights. So many, if most, developments contain policies that may be regarded as positive in nature without specifically identifying, and this is a bit that I think we need, the land development which would be inhibited. So, for example, you can have development plan policies that encourage employment-generating activities, headline policies, which must be read to consistent with other planned policies. A general policy of things that are good. We will encourage cycling. Exactly, it gives you a very good example, Mike. The policy to encourage cycling. It doesn't mean, therefore, that unspecified land is therefore, we can say, oh, well, they encourage cycling across the whole of the county, so this is... So I don't think, with respect, the learned judge is saying much more than that there are all sorts of policies that you have, and you can see some of the extracts here, that are general policies that would apply, or this general policy that says this sort of developments which use renewable energy will be encouraged, or there is a presumption in favour of development that uses renewable.
How could anybody suppose that identified any land?
My lord, that's right.
That really needs saying. I mean, that's what leads one to suppose that he meant something different because he used words of degree like specifically identifying and sufficient nexus.
Well, he says simply because their plan generally encourage certain categories of land or in certain circumstances to restrict, if not most, development that may be regarded as, without specifically identifying the land development of which would be inhibited. So they don't, as I understand him saying, the general policies that encourage renewable energy recycling
completely disembodied from any connection
with no and that's why he's required a more specific nexus which simply creates a potential for you and aligns more closely with statutory purposes of identifying the land by one means or another. So those policies that encourage renewable aren't related to the land, they're related to the general use of land. So they of themselves obviously wouldn't be good enough. I come forward and say, well, I can put a wind turbine on my client's site, that's renewable. Here's a policy that says there's a presumption in favour of this development. There's a development plan that supports but it doesn't relate to the land. If there was a policy, take renewables or something, that said within this area we are looking, I'm now making policy up on the hoof, but saying we want to have a wind farm or a renewable energy area, and this is the area where it's going to be directed. Then there may be arguments directed, or the land within this area, there'll be a presumption in favour of renewable development. There may be then arguments.
We will encourage tourism in Salisbury.
Yeah. Well, that wouldn't be well, just a policy to encourage development in Salisbury. I'd have my. Well, I'm not pursuing. I wouldn't push that. Far. Although, as we know, Salisbury is an interesting example. It has a very famous cathedral, apparently. Yes. But my lord, I think, in fairness to the judge, that is what he's saying. He's saying that statement of the obvious, that you've got to show that it's identified land. Now here, the issue isn't that the land isn't identified. We know the policies apply to this land. There's no issue. Well, CP1, CP2. It's an argument about what does potential development mean. That's what this case is about. As much as my learned friend will say, I identify potential. It means, what does potential development mean? And you have your lordships have submissions on that. And the question also is also, one has to remember that one is looking at development plans, setting up policies, and in terms of identifying land, it isn't the identification of the type or likelihood of development. Yeah. It's just the identification of the land for potential developments. Yeah. A learned friend seeks to say that the identification goes to somehow an assessment of the likelihood of development.
Right, I think we've been over this.
You've been that's fine. And my lord, on the judgment, the only other point I make is I just repeat, but without articulating, that the situation in respect of this case and these facts was it was accepted. Yeah. That
suitable for development.
And that's why I referred to it in my opinion. Yeah. It was before the judge, and so it was accepted that we would meet even Mr. Brown, one of his tests. There are quite a lot of tests, but the appropriate development and in principle.
But that's not enough for you, because you've got to be identified in the development plan. The mere fact that the planning officers think the land's suitable for developers doesn't really help you, does it?
No, that's because they relied on CP1 and CP2.
We're always going back to the development.
Well, no. It's their interpretation of CP1 and CP2.
Which is a matter of law for the court.
Oh, that's a matter of law for the court. Yes, I accept that.
So it's no more than the jury point that that's what they thought it meant.
No, but it's important when you're appealing from a High Court judge that the position before the High Court judge before was an acceptance that. Yeah. And it may, say, a powerful jury point. I know advocates change and can say that policy means something else. But up until now, this hearing before this court, before not just the court below, but before other planning appeal tribunals, the inspector, it's always been this council's position that CP1 and CP2 meant that you, in principle, appropriate for development. Those are the words they use. I mean, ultimately, it's a matter for the court. But since my learned friend has been talking about, in his experience, what's been happening, it's quite relevant, we say, to this court coming to it afresh, to understand actually, and your lordship will make the own view, how we say the policy is properly understood. And it is, yes, it's a jury point at the end of the day, but in my submission, quite a powerful one that historically...
Well, we're missing the other 9, Mr. James.
There are
3 of us here.
I know, well, we'll see. So, my lords, that's it. My lord, those are
thank you very much.
submissions. Thank you.
Yes, Mr. Brown, you reply.
My lord, if I may. My lord, can I deal first with the word potential?
Yeah.
My learned friend chastises me for not having explained to your lordships what, in my submission, the significance of that word is. I hope when I was making my submission to your lordships got my point, that in my submission, when one looks at the word potential, it does nothing more or nothing less than recognise the fact that whether or not land comes forward isn't something the development plan can control. Yeah. It's about whether or not a developer chooses to bring it forward. And my learned friend said things may or may not happen. But, my lord, it goes beyond that, because if, as my learned friend indicates, that the word potential has got some bearing not on the prospects that a landowner might bring a land forward, but on the question whether or not it would get planning permission, then in my submission one is onto an extremely slippery slope in terms of where it is that one draws the line before concluding that effectively everywhere is identified in a development plan as having potential. And your lordships will recall when we went to policy CP2, I drew your lordship's attention to the fact that even outside the limits to built development, it's not a complete preclusion. There are particular classes of development which will be allowed there. Now, on my learned friend's argument in my submission, that would mean that there is certainly potential for the countryside, and the countryside is identified. It's everything that's outside the limits to built development. There's no lack of uncertainty as to what the countryside is. It may be a very broad area of land indeed, but it's quite clear. And certainly the possibility, the potential for development, as my learned friend uses that word, exists there. If one looks at paragraph 416 of the plan, which my learned friend took you to, it's a tab 1 of the supplementary bundle. Which is talking about the settlement boundaries for small villages being removed, and the general presumption against development outside the defined limits of development. But then one sees, however, some very modest development may be appropriate at small villages to respond to local needs. So, on my learned friend's approach to potential, there is certainly potential in small villages for modest levels of development. My lord gave the example of the Greenbelt at possibly one of the more extreme ends of the spectrum, where Greenbelt is a place generally where one would not expect to get development, but even national policy says that you can have development there if there are very special circumstances. And my lords, I put that in the context of one of the discussion between your lordships and my learned friend, where question was put in relation to policies which, for example, made it clear that in general one would not seek to develop, for example, school playing fields or areas of open space other than in very particular circumstances, such as where, for example, there was an overriding need or alternative provision being made somewhere. And my learned friend's answer to your lordship was that even in those cases the potential exists. And in my submission, at that point, when one gets to a situation where there is a clear development plan policy which seeks to steer development away from a location, other than in very unusual circumstances, to conclude that that land is identified for potential development in the plan is an extraordinary conclusion, because you are saying it's identified for potential when in fact the plan is steering you in precisely the opposite.
Sorry, I just hesitate to interrupt them. My learned friend doesn't. I hope I made it very clear when I was given that example was in the context of CP1, CP2, and if there was a policy, I wasn't just talking about you only have one policy, which is about school playing field.
You were talking about policies pulling in different directions, I think.
Yes, we had CP1 and CP2, and my lord put to me a school playing field within that context with a policy, and I made the submission I did. I didn't make the submission where you had no policy such as CP1, CP2, and all you had was a school playing field policy.
Well, my lord,
I'm just saying I didn't make that submission.
I'm grateful for the clarification, Lord, but my point stands, and it's a point that I made in my opening submissions, that if you have CP1, which draws a line around the settlement boundary, and then a particular policy which draws a line around a smaller area within that and says not here, it would be extraordinary to say that because of CP1 and CP2, the development plan identifies that land for development. And that argument, if one looks at the discussion about potential and what potential means, it's equally true where you have a policy which doesn't say absolutely no, no, never over my dead body, but says very, very rarely and only in exceptional circumstances. That's a prohibitive policy. To say in those circumstances that because it's within the settlement boundary, it's identified for potential development. In my submission, it simply does. It's not the way in which anybody would
But
look
I mean,
at
on the
that.
facts of this case, there is no such prohibitive policy.
Well, my lord, I want to deal with that. I recognise that. I've accepted it from the word go. It's quite clear. But, my lords, it comes then to the discussion that again between your lordships and my learned friend in relation to the Swiss cheese argument.
Yeah.
Now, my lord, on this, I hate to say, having heard the way the point's been put by my learned friend, it's not entirely clear to me where he stands, because he started by saying to your lordship, and I wrote it down, it's not a Swiss cheese. If you wanted to take it out of CP1, CP2, you could do that. Now, my lord, if it's not a Swiss cheese, where you isolate the area and it becomes a whole, the only way in which you can take it out of CP1, CP2 is by having another policy which is then weighed in the overall balance as part of the planning consideration.
I think Mr. Jones's solution was to say CP1 and CP2 apply to land within the settlement boundaries, except where policy open space 3 applies.
Well, but my lord, that one could have policy CP2 saying within the settlement boundary you can have these things except in the following circumstances. You could do that, but it is equally possible, and indeed in the way plans are set out, where you tend not to cross-refer to other policies of the plan in one policy because you read the plan as a whole. You'd have CP1, which draws the line around the settlement. You'd then have a policy that deals with open space. You'd have a policy that deals with school playing fields, a policy that deals with sites of interest for nature conservation, whatever it may be. Now, in my submission, my lord, it makes no sense to say that the first of those, where policy CP2 expressly says, except in the following cases, that's a successful carve-out, but the situation where you've got to look to the discrete policies is not. And the problem with that, it goes back to the point that I made, that it's not the way I've put it, it's the way the case was argued below. You can look at CP1 on its own, it identifies. You can look at CP2 on its own, it identifies. Once one recognises that you can have a carve-out which is not, as it were, a Swiss cheese approach, but you can have something which says, well, we will resist the loss of open space, then inevitably you end up having to go through the process of asking, if I look at the plan as a whole, would permission be granted? And at one stage my learned friend said to your lordship in response to a question, of course one has to look at the plan as a whole in order to find out whether it identifies land. But if one has to look at the plan as a whole in that context, one really is into the realms of a world in which the registration authority has to ask itself, would planning permission be granted? And my learned friend accepts that that's not a realistic scenario. It's not what's proposed. It's not appropriate the registration authority should do it, and it's actually almost impossible for it to do it in the absence of a particular application against which it's going to measure those particular policies. And of course, when somebody applies for town and village green registration, they don't come along with a here's what I might have, or here's what a developer might have done, assessing against that proposal. So, my lords, in my submission, there is a real issue here in terms of how it is that one reconciles the arguments CP1, CP2 identify with my learned friend's acceptance that in some way, shape or form, whether it's a Swiss cheese or whether it's some other criteria based, that it's possible for the development plan, the rest of the development plan, to take things out of that.
I'm sorry, I just have to say, by redrafting the plan, that's the whole point. You redraft CP1, CP2.
No, I think Mr. Jones...
I won't say anything more, but...
So, yes, okay. In my submission, redrafting would end up with one or two of the scenarios that I've indicated, and either way, in my submission, one's back to the same point. You can't judge it by looking at CP1, CP2 alone. You have to go elsewhere.
But we are told by Parliament, are we not, in the Commons Act, to look at the development plan.
Yes.
So Parliament plainly envisages that it's the drafters of the development plan who are going to be identifying land for potential.
Indeed, my lord, but the development plan provides a set of rules, which, or not rules, but well, call them rules, not binding rules, but policies, principles, which are then applied in deciding whether or not permission should be granted. Now, the determination doesn't have to be made in accordance with the development plan, but let's just suppose for the moment that it's going to be made in accordance with the development. That's the normal starting point. It's what section 38.6 requires. Start with the development plan. Now, you have the set of rules there, and at the end of it, if a local planning authority has a planning application, it comes out with an answer yes or no which is a consequence of applying the principles that are in the plan. But that doesn't mean that the plan has identified that land as appropriate or suitable for development, or even identified it for development. It gives you the rules that you can apply in order to work out whether development is acceptable, but that's not the same as identifying it. And it's the identification which is required by paragraph 4. And, my lords, in my submission, if one concludes, and it's the point about this particular site not being the subject of any countervailing designation, my lords, if the sole basis for upholding the decision below is that there is no countervailing policy in this case, and therefore on this particular site is in some way identified, I've already set out for your lordships the reasons why in my submission one shouldn't go down that road. But my lord, from the appellant's perspective, that is a much more palatable basis for the decision than what we have at the moment, which is that CP1, CP2 answer the question, and therefore it wouldn't matter what else the judgment says. If the basis of your lordship's judgment is that it's possible to have a look at the other policies, so one has to bring those into play, then, my lords, by all means say so, and your lordships will appreciate that one of the reasons why we are here, we've got no particular axe to grind for this site.
Slide, if that's
Yeah,
what you say.
my client has a number of other applications for village greens within the urban areas in its area, and it is concerned to know how it should approach them on the basis of the judgment. If they're within a settlement boundary, that's a way. Well, I'm not inviting your lordship to uphold the decision on other grounds, but I am indicating that if your lordship's going to go down my learned friend's route of saying, well, one has to look, please make that clear, because then at least it answers part of the problem, the concern that my clients have, that you simply erase entire areas simply because they're in an urban area. But I do say that against the backdrop of my primary submission, that simply moves the problem from registration authority from one area to another, because it puts it in the shoes, effectively, of having to be the local planning authority. My lord, can I move from that to my learned friend's submission that, if I'm right, then first of all, this is his words, business as usual, and secondly, that the effect of the Commons registration, the amendments to 15C, would be castrated at birth, were I think his words. My lords, it would not be the case that this is business as usual, because on my submission, allocation, or something akin to allocation, a preferred area, an identified site, or means of doing it, will attract the protection that is there in 15C. And I say that's what was intended to do.
Well, I think his point, really, was not so much about the development plan document as the draft development plan document, which hasn't yet come into effect. And I think, as I understood it, the point was that as soon as the residents' groups see the publication of the draft, they will rush off and make their TVG up.
Well, my lord, can I take you back then to Schedule 1A,
Yeah.
please? It's tab A of the bundle.
I think that was the point that Mr. James was making.
Yeah. Yes. My lords, we've looked at paragraph 4 of Schedule 1A.
Yes.
And I draw your attention to paragraph 3.
Yes.
A draft of a development plan identifies the land for potential development is published for consultation in accordance with the regulations. So as soon as the local authority goes out for consultation on an early draft, and your lordship will know there are different stages, one goes through a draft, usually an issues and options draft, called Regulation 18 draft, there's an early draft, and then there's the draft that will be published for consultation before it's submitted to the Secretary of State. So paragraph 3 is intended to say, well, you don't have to wait till you've adopted the plan. As soon as you go out to consultation on your draft, the protection applies, and your lordship will see that protection continues.
Yeah.
And while that plan is going through the process, and of course once it becomes adopted, it falls away, but immediately the protection of an adopted development plan under paragraph 4 creeps in order to step into the place. And, my lord, the way the point was put by my learned friend was not just in relation to specific sites where, and if there's specific allocation, or proposed allocation in a draft plan, there will be no argument between us that paragraph 3 would apply. His point was also, what happens if you say Salisbury is going to accommodate another 4,000 houses, and instantly everybody scrabbles around to have a piece of green space outside their home allocated as a town and village green because they are worried that some of those 4,000 houses are going to go in their particular area. Well, my lord, the fact that one is told Salisbury is going to have 4,000 homes, whatever it may be, directed towards it, does not mean that you're identifying everywhere in Salisbury as suitable for that. And my learned friend took you to the tables with the figures for Wootton Bassett and points out that, well, these are homes that are going to need to be accommodated. But your lordship's seen from both the policy and the text that it's not suggested that all of those units are going to be found within the existing settlement boundaries of Wootton Bassett. There's express reference there to the fact that there will need to be an allocations DPD which will extend the boundaries and look for additional land. So the mere fact that if and to the extent that it's possible, one will, on suitable sites, one would accommodate some of that need within Wootton Bassett. In my submission, it doesn't lead to a situation where you castrate the system. You would castrate the system if, when a local authority gets to the point of saying, this is where we think the development should go, these are the sites we've got in mind, then in those circumstances, it would plainly fall foul of what the legislation sets out in paragraph 3. But in general terms, the mere fact that an indicative level of growth is identified without indicating where within an area as large as Salisbury or Chippenham or Trowbridge it is not in my submission enough, and your lordships have my submissions about that. My lords, can I then just go back to the judgment below of the observations that were made about paragraph 65, and in particular what Mr. Morgan said at that stage. And it may be, my lords, in the light of the comment your lordship made to Mr. Jones a moment ago, that it's academic, but your lordships were drawn to the last part of paragraph 65. Mr. Morgan accepted there were no constraints that applied to the land. Well, that's true. But, my lord, the absence of constraints doesn't mean land is identified. It just means it's not constrained. Indeed, it's clear from a Section 78 decision on appeal, the council hadn't disputed the land was suitable in principle for development. Well, my lord, that's a matter of record. It is the case. And that's what Mr. Morgan was accepting. But I don't read into his acceptance, certainly as it's recorded there, that the plan itself accepts the principle of development. Your lordship's seen the extract which indicates that was the officer's view, and as you rightly say, that was their view, but it's a matter of law for this court. My lords, I think I've only one last point subject to any questions your lordships have. Let me just check. Yes, my lord, in relation to the overall point about my lord Justice Henderson, in relation to the restriction of rights and the framework of this Act. Now, my learned friend says quite rightly, well, the town and village green legislation is itself an incursion into the ordinary property rights. My lord, that is correct, but of course, as my learned friend indicated, what the legislation does is enshrine what had in fact been a well-established principle in relation to town and village greens. Your lordships will know there are similar principles in relation to rights of way in this country. They're not identical, but they are very similar. If you have the user for the relevant period, then a right is established, and once a right of way is established, once a highway, always a highway.
I think the Commons Act went a lot further than the common law.
Well, my lord,
It's certainly in allowing new greens to be created in very unlikely places, like car parks.
my lord, it is certainly the case that since that, the concept of what could be a village green has become rather wider than it was previously thought to be.
Bachelor's Acre was partly a car park.
Indeed,
Track
my lord,
grounds
and
was a piece
indeed,
of derelict scrubland.
yes, my lord, I don't
Logistics is part of
think it didn't go further, but nonetheless, if one were to one goes back to the essential point, which is that the concept that you can, the public the community, the local neighbourhood, can acquire rights by long user has been very well established. And yes, that's an incursion on prior property rights, but it nonetheless gives rise to a right which this country has recognised for a very long time. And to that extent, in my submission, my Lord, it is absolutely correct that this is a piece of legislation which is shrinking back, reducing an existing right, now codified in statute, but still a right nonetheless. And that in those circumstances, I don't depend upon this for my submission, but in those circumstances it is, in my submission, appropriate to be cautious in not taking that reduction of right any further than is necessary. Would your Lordships give me just one brief moment? My Lord, I'm very grateful, unless you have any questions.
Thank you very much, Mr. Clark. We'll rise for a couple of minutes. Don't go away and just see where we go to next.
Court rise.
No. Thank you for because I did.
No, of course. No, I was thinking we're right a bit impressive. It was the right. Well, I'm particularly given the messages. What that precisely? I don't think there is a.
I suspect the mere fact
Yeah, well, that's
it's rather different situation than the previous one.
Yes.
Absolutely. Yeah. No, well, and actually.
Good.
Yeah.
That's all we have.
Well, that's the irritating thing.
Yeah.
This is the irritating thing.
It shouldn't alter the general approach, as you rightly discussed.
Lost Holly.
Yeah, she did have a show this afternoon, yeah.
Oh, I think they will. Not least of all because I think.
It's funny you should mention a juror. It's just like that.
Well, they mentioned the jury point.
Yes, that's all good.
We'd like to compliment you on the clarity of your respective submissions, but we are going to dismiss the appeal for reasons to be given later, and in consequence of that we need not hear from you on any of the remaining issues. You will get a draft judgment in the usual way, which we will obviously use to correct our spelling and grammar, but not to re-argue the case. and we would hope that in the light of the draft judgments you will be able to agree an order. If you can't agree an order, then please make submissions in writing on the form of the order, and we will deal with that on the papers.
Thank you, my lord.
Thank you, my lord.
Thank you very much.
Thank you.
Well done, Rick.
They kind of went down the line as the day went on. So obviously never got there enough.